Well, welcome to everybody for what is going to be our last Berman lecture in the third year. 11th, we had a busy year and we have drawn it out till deep into July because I thought that it was a great occasion to have Michael Bazyler speak to, Professor Michael Bazyler speak to in this series. Originally, for those of you who were at its very beginning, remember that it started out with only post-Holocaust until anti-Semitism became so strong that we combined the two. There are very, very, very few experts on restitution in the world. I mean, academic experts. In fact, a number of books have been written. Very few, hardly any, have been written by an academic expert. And I think that for us to have Professor Bazyler here really brings perhaps, I think the sole academic book, I mean I'm not speaking about somebody who wrote a PhD thesis on a small fragment, but this book, Holocaust Justice, The Battle for Restitution in America's Courts, is the book which summarizes the legal aspects of the restitution issue, which has this miraculous story how the United States, more than 50 years after the war, suddenly gets involved in prodding the Europeans into doing what they hadn't done for 50 years. Of course, you have had another aspect of it in the interview I published in Post-Holocaust and Anti-Semitism with Stuart Eisenstadt, which is from the practical side. And Stuart Eisenstadt's book, of course, is a remarkable book, but it's not an academic book. So I won't keep you very much longer. We will start again either before or after Rosh Hashanah with the fourth year. Mrs. Berman has informed us that she wants to go on and sponsor this series of lectures, for which we are grateful to her. And the floor is yours, Michael.
Manfred, thank you very much. I'm very honored to be here. Such a distinguished crowd, all the different people that I've been introduced to. My head is almost spinning, trying to remember all the people that are here. Thank you so much for coming. I wanted to just briefly tell you why I'm here. I'm spending a month in Israel. The law school I teach at Whittier College. Most people know it because Richard Nixon graduated from there. He's our most distinguished graduate. We are one of the 5 law schools in the United States that has a summer school in Israel. And for the last 3 years, all of the law schools, because of the situation, have canceled their programs. And we made a commitment this year not to cancel the program. And because our program is accredited by the American Bar Association, it means that any law student in any law school in the United States can come and attend this program and to go ahead and get credit at their home school. And so I with pride tell you that we have a group of 20 very special law students from 11 different law schools in the United States studying for 1 month at Bar-Ilan University. I teach a course called Holocaust, Genocide, and the Law, and then we have 2 other professors from Bar-Ilan University teaching 2 other courses. And in fact, tomorrow I'm bringing my students to Jerusalem. Just because they're such a special group, we have a private meeting with President Barak of the Supreme Court, and we're going to also take him to Yad Vashem and then give him a cultural tour. So we're trying to, within the 1 month, squeeze as much as possible. It seemed like a long time. It seems like a very short time. Both myself and the student want to go ahead and extend it much longer, but law school begins in August, so we have to finish and go back. But we hope that this is the beginning of the start, where now, since we came back, other law schools would then in turn follow and say it is okay, it's fine to go ahead and have more law students come. So I just want to mention that to you, and with pride, of the program. And without the students, it would not have been possible. If these students had not signed up, we would not have been here. I want to begin my presentation with a story, and it goes back to my early years as a lawyer, a practicing lawyer, and then a law professor. In 1982, I was asked to represent a gentleman who was an Argentine Jew who was imprisoned, then tortured, and his property taken away in Argentina by the military junta that came into power in 1976. And in fact, the largest piece of property they took away was a hotel that also did business with the United States. And he fled to the United States, and the Argentine military followed him, in fact tried to extradite him back to Argentina. And saying that he would not get any peace from them, in 1982 we filed a lawsuit against the Republic of Argentina for both torture and the property deprivation. And the case was filed in federal court in Los Angeles, because that's where he was residing. And the case went on for 14 years. It had 2 visits to the United States Supreme Court. Every time we would win a motion in the case that would allow us to go to trial, Argentina would ask would appeal, and then at whatever point it was necessary for them to ask for the Supreme Court to look at it. And when they exhausted all these appeal options, in 1996, a week before trial was going to start, Argentina settled. They basically sent a delegation, and we ended up settling the case. The reason I mention this story is to put this in perspective of what happened in the United States with Holocaust restitution. You know, it's not atypical for a case to go for a decade or longer in the United States to try to get some kind of a settlement, if there is a success. What happened in Holocaust restitution, from the point of view as a lawyer and as a law professor looking at this, I have to tell you, is very amazing that it took such a short period of time. I'm sure all of you know the story, how it came about. In 1995, the World Jewish Congress, with Edgar Bronfman and other individuals working with him, began focusing upon the Swiss banks and the Swiss government for their insidious role in World War II. So we had this idea before of Switzerland as being the land of cuckoo clocks and Heidi and Swiss watches, and all of a sudden there was a whole new image that came about, and there were a number of books that were published at the time, some from Israeli academics or journalists, talking about exactly what the nefarious role of the Swiss was during the war. In 1996, the litigation began in the United States with the filing of 3 class action lawsuits in federal court in Brooklyn. Those lawsuits were consolidated before one judge, Edward Corman, who still is in charge of the settlement process. And then in August 1998, the case is settled. So you see, it's a very short period of time that it occurred. And the settlement in August 1998 was for $1.25 billion, which at that time was the largest settlement of a human rights case in United States history. And I emphasize that because it is a human rights case. All right? These were claims filed against Swiss banks by survivors of the Holocaust, seeking compensation, restitution of dormant bank accounts, and also to try to get compensation for the profiteering that the Swiss banks did. And from a point of view of American lawyers, it was also a very strange settlement, because the payors were the 2 largest Swiss banks, UBS and Credit Suisse. But in turn for paying the $1.25 billion, they asked for a release, as payers want in every case. But in their release, they wanted to release the entire Swiss nation. All right? So even though they were paying, they were saying, we're paying for everybody. So that afterwards, once the money is paid out, you could no longer in any litigation anywhere in the world mention Switzerland in World War II in the same lawsuit. Right? And basically that's what they got. They really were not concerned about litigation in Switzerland or litigation in any of the European countries. They were concerned about the class action litigation in American courts. That same month, in August 1998, the first Nazi looted art case was settled, right on the eve of trial. Soon afterwards, with regard to the insurance claims, there was an international commission that was formed in order to go ahead and settle these claims, because the insurance companies that were sued recognized that the same thing that happened in the Swiss banks was going to happen to them. And the commission is still in existence. If we have time, I can talk more about it. In fact, last year I testified in Congress on some of the problems, the major problems that the International Commission on Holocaust-era insurance claims has. And then came in December 1999 the settlement with Germany, both with the German government and the German companies for 10 billion Deutschmarks, which topped the settlement with the Swiss banks. And this is what was called the Millennium Settlement. The Germans wanted to close the books of the 20th century. In the 20th century, they were able to do so in December 1999. Then at the end of the Clinton administration, we're now going about a year later, December of 2000, January 2001, there were settlements with the French banks and the Austrian government. If we had time, I would go some more details. In the book, I go through each one of these settlements. I devote a chapter to one of them, telling both the legal story and the political story. But if you take all those numbers together, and I'm speaking now strictly in dollar figures, the estimate is that there was about between $8 billion to $11 billion of new funds collected. And as Manfred has pointed out, it really is an amazing story to think about the fact that more than 50 years after the end of World War II, that these financial claims would be settled, and they would be settled in the United States, which was not the site, of the Holocaust, and it would be settled, through the political and the judicial process. Now, a number of individuals that have talked about this have talked about the various factors that came together in the United States, that made this happen. And one of those individuals, who was a law professor at New York University, Bert Newborn, who's also involved in this litigation, compared the settlements to, he said, a three-legged stool. He said, in order for the stool to stand up, you need 3 legs. So he mentioned the following 3 legs, and I agree with this. The first leg necessary was the Jewish organizations that came together and put the pressure upon the various European defendants, both governments and private corporations. The second were the politicos, both state and federal government officials in the United States that end up putting pressure, and let me go ahead and mention just 2. One Manfred mentioned, which is Stuart Eisenstadt, who was appointed by President Clinton as being his special envoy in this matter, and really acted as interlocutor. He and the representative of the German Chancellor were the ones that created the so-called Big Tent, brought all the parties together interested in the German claims, and were able to go ahead and effect a settlement. And then at the state level, you had a number of officials in the various states putting economic pressure against these various defendants. One person I mentioned is Ellen Hevesy, who was at that time the controller, the chief financial officer for the city of New York, who basically said to the Swiss banks, unless you settle, we're going to take our investments from the city of New York and pull them away from you. And he instituted this plan called the rolling sanctions. He said, if you don't do this by a certain date, we'll take step 1. If you don't settle after that, we take step 2. And there's not a coincidence that the settlement occurred with the Swiss in August 1998, because it was a month before, in September 1998, when the first set of sanctions were supposed to be coming about. Now, it's interesting that in those sanctions, that the federal government, the Clinton administration, including Eisenstadt, were completely against that. And in fact, there were full-page ads published in the New York Times about a trade war with Switzerland, and Eisenstadt was saying this should not be done, and in fact, he was wrong. People who are, in my book, I talk about Stuart Eisenstadt, and he really is a hero, of this movement, a very important personality, but I think that he miscalculated. Now, if you talk to Stu, he may say, well, privately I thought it was a good idea, but I was representing the Clinton administration and the federal government, and this was the position that I had to take. Now, the third stool on that, and this is the one that I focus in the book, is the lawyers, the American system of justice. Until the class action lawsuits were filed against the Swiss banks and the German companies, and the French banks, these defendants were very happy to go ahead and, have a number of technical, obstacles for over 50 years. But it was the class action litigation. And in fact, Chancellor Schroeder, when he put together the first group of 12 German companies to try to effect the settlement, specifically mentioned the class action litigation. And what the Germans wanted, they actually invented a term for this, they wanted legal peace, meaning that they were going to pay only if all the lawsuits were settled, and they wanted something more than the Swiss, because they wanted the United States government to come in, okay, and to kind of give its blessing on the settlement. And if anybody ever filed a lawsuit against Germany, in an American court in regard to it, they wanted the executive to come on in and to object to that lawsuit, which in fact they got as the statement of interest. And in fact, there was a gentleman in California who said, I don't want a settlement. I want to go against the German company who was my slave master during World War II. He went up to the Federal Court of Appeals, and the court said, I'm sorry, you can't do this. You have to be part of the settlement. Now, there is a fourth leg to this stool, which I think Professor Newborn missed. And I think it's an important leg here, and that is the press. Okay? The media really kept attention on this subject. And in fact, there were more articles published in the American press on the Holocaust from 1995 to 2000 than for the last 50 years before that. And I think these page one stories, which make great stories, and it's something that the public was very much interested in, really kept it alive and made it known to the various defendants that they were going to have a very high price to pay, for sort of the public hold which they have. And their sorry history from World War II was going to be exposed, and they wanted to get this behind them. They wanted to be seen, using the American vernacular, as the good guys as opposed to the bad guys. Now, let me just go ahead and mention sort of why I think that this has been a success. And I think there are two markers for this. The first one really comes from a Chinese proverb that says that failure is an orphan, but success has many parents. And one of the things that I have seen is that for these settlements, you have many, many different groups, okay, that say, no, it's us. So the lawyers would say, it's only because that this occurred. And the politicians say, no, the lawyers, not that important, it's us. And the Jewish organizations, different organizations, no, it's us that it does that. So I think that's an important indication. If they didn't see it as a success, they wouldn't be clamoring for credit for it. The second one, and it's something that I devoted an entire chapter to the book, is really seeing how other victims of other historical wrongs are not using the Holocaust restitution litigation political model as a way to also go ahead and try to get the same kind of success. So whenever I talk to Holocaust survivors in Israel, in the United States, in Europe, and they complain about the results, I say to them, talk to the American POWs who were slaves of Japan. Talk to individuals who were trying to get restitution compensation from American insurance companies going back to the Armenian genocide. Look at the claims being made by African Americans for reparations. All of these individuals, all these activists, would very much like to be in the shoes of the Holocaust survivors. And in fact, I talk about in the book about one of the lawyers, major lawyers involved in Holocaust restitution litigation, Michael Hausfeld from Washington, D.C., joining forces with Johnny Cochran. Anybody remember Johnny Cochran of the O.J. Simpson dream team? Well, they formed a new dream team to go ahead and pursue African American litigation. Now, we can talk about the differences between filing claims for African American restitution going back to slavery and the claims being made by Holocaust survivors, but there is a connection there, a true connection. Now, that's the positive. Let me go ahead and speak about the negative. And what I want to do in a short period of time, and I promise, Manfred, that I will try to stick within 30 minutes, and please tell me when I'm getting close, and I will stop. As a law professor, I can keep on talking and talking and talking, is some of the problems, and I just want to point them out so we can have a discussion about this. This is what I call the gray zones of Holocaust restitution. Problems that came as a result of the settlement that for many looking at this saying, you know what, I don't think it was worth it. I don't think these are, the campaign was one that should have occurred, despite all the positive things that I mentioned. So the first gray zone, and I'm taking the term from Primo Levi, is the question of, does the seeking of restitution funds diminish the memory and distort the history of the Holocaust? My first visit to this wonderful place was when Abe Foxman gave a talk here a number of weeks ago. And Foxman, in December 1998, published an editorial, a very prominent editorial in the Wall Street Journal, where he said he didn't want money to be the last soundbite of the Holocaust. I think it's a very good soundbite that he said. It's important. He didn't want money to be the last soundbite of the Holocaust. He didn't want people to think that the Jews were murdered because for their Swiss bank accounts or for their Picassos, or for their assets, because they were murdered because they were Jews. And so he felt that the price was not worth paying. And in fact, at that time, he also looked at the wider picture. This is before the larger anti-Semitism problem came about. And he thought it would not be good for the Jews, it would not be good for the state of Israel. And I think it's important to consider that. I think we can have a discussion. I want to, as a counterpoint, point out it's just a quote from Elie Wiesel in Time magazine in 1997. And Elie says as follows: "If all the money in the Swiss banks were turned over, it would not bring back the life of one child. But the money is a symbol. It is also a part of the story. And if you suppress any part of the story, it comes back later with a vengeance." And I think it's important that not only the killing, but the massive theft, is an important part of the story. And it's a part of the story that has not been looked at. And as a lawyer, as a human rights activist looking at this, and not being a Holocaust historian, I have to tell you, I was outraged to see the various European defendants, how they profited during the Holocaust, right? And how they failed to recognize that. So I think it became very important in order to get that compensation story and the restitution story out, right? Now, with regard to that, the biggest problem that came about is distribution. It's easy, looking at the larger picture, to go ahead, it was easy, all right, to go ahead and get these settlements. The hard part, and the much longer part, since 1998, 1999, 2000, we're now 2004, is how do you make a fair and equitable distribution? And it's really difficult to do. In the very first book that was written on the subject, it was by two journalists in the Financial Times who covered this in their newspaper. Their very last chapter, they have a section called Jew versus Jew, all right? And they talk about the fact of, various Jewish groups, individuals, going ahead and fighting with each other, and they were kind of making a prediction. And in my book, I make a short reference to that, and I say, that's not right. That's not what it's about. It really is, various groups trying to recognize what happened here. And I have to tell you that over time, as I see this infighting increasing, there is an aspect here of, Jew versus Jew, and various organizations, and various interest groups fighting on this. And some of the infighting, I have to tell you, does not look good. I don't think that the best part of it comes out. Now, with that in mind, I just have to note that any time you have talk about distribution and money, there's always problems that will arise. A good example of this is after 9/11. There was a fund created in New York for the distribution to the various families. And at the beginning, everybody was in favor for that. And you had, I look at this and I see in that 9/11 fund very similar type of infighting. And it's not their Jew versus Jew, it's just different sets of claimants, different people looking at this, trying to somehow put a monetary price on the suffering, which is impossible to go ahead and do so, but which is the only way that we can do this. Now, as a result of this, to try to put a monetary price, to try to get some kind of measure of compensation, to try to distribute a limited amount of funds, other problems arose. Another issue that came about from this, another gray area, is that in order to make a proper distribution, people have tried to set out an agreed upon definition of who is a survivor of the Holocaust. Right? And I have to tell you, I think it's an impossible definition. Again, I don't come to this area as a Holocaust historian. I come from this as someone who's looking from a legal point of view, as a son of Holocaust survivors, but something I never looked at closely to try to put definitions. And we as lawyers always try to put definitions. And I think the definition for this is impossible. And what is happening, and I see this coming about in the Swiss settlement as the infighting there has grown kind of to its largest extent, is people arguing, well, no, you're not a survivor, I'm a survivor, all right? Or you didn't suffer enough. And I find this interesting phenomenon. I have to share this with you. Both my parents were flight survivors. My father was from Warsaw, my mother's from the Ukraine. They met in Uzbekistan, in Tashkent, where I was born. I then emigrated. We emigrated to Poland, and at age 11 we came to the United States. So I have sympathy for the survivors in the former Soviet Union. And in my mind, flight survivors are survivors. There's a law professor at Fordham University, Thane Rosenbaum, who testified before Judge Corman when he had the April hearing, and he said, no, the flight survivors are not real survivors, okay? You have to be under Nazi occupation. I have to tell you the stories I heard from my parents as to what they went through. I can't, you know, I'm offended by them not being called survivors. But I also can step back and see an interesting phenomenon, that the children of survivors are now fighting the fight which their parents did. So I'm the representative, I see myself as kind of the flight survivors, fighting the same battles that I guess survivors did at the time, and Thane Rosenbaum is doing the other way. And I'm not sure, it's an interesting phenomenon, how that will continue, at least, I guess with so many psychologists here in the audience, I'm doing a self-analysis of exactly what is happening. Now, another gray zone issue. Should any of the restitution money be used for remembrance and education? You know, as a law professor, I very much would like someone to create a chair in Holocaust and human rights law at my law school, and I would very much take that chair. But if it was offered for some of the restitution funds, I'm not sure whether that would be the best way to spend the money. And in fact, Holocaust survivors say that none of the money should be used for remembrance or education. In the German settlement fund, the Germans insisted. They have a future fund where a portion, they say, will be used to continue the memory of the Holocaust. It's important to do so as the survivors are dying out. And I understand what the issue is, but I just want to point out the two problems with that. And then I want to point out two issues that are very close to my heart. Okay? And that has to do with the lawyers involved in litigation. One of the questions is this, and I've had a lot of debates about this with lawyers and with Jewish activists, is that should the lawyers that have filed the lawsuits, should they have collected fees from these cases? So as an example, in the Swiss bank settlement, a large proportion of the lawyers took the cases on pro bono and did not take any fees. One of the law firms actually earned a fee of $1 million and donated it to Columbia University, where the major partner comes from, this law firm, to create a human rights center in memory of Holocaust survivors. But a portion of the lawyers who are sole practitioners, who say, we couldn't do this, they asked for fees, and they collected $22.5 million as attorney's fees. Now, I have to tell you, out of $1.25 billion, that amounts to less than 2%. And if you look at the lawyers who, for instance, collected fees in the tobacco litigation, it's minuscule what they got. And I think that Judge Corman did a very good job in making sure that the fees were as little as possible. In the German settlement, all of the lawyers that went pro bono said, we can't do this. They asked for fees. And there was $60 million, exactly $59.9 million in fees that were paid, which also amounts to a small percentage, 1.2%, of the fees. And so it's a very controversial issue. Should the lawyers have taken a percentage of the fees? Let me give you an example. In the German settlement, the payout to a Holocaust survivor, so let's say someone who survived, Auschwitz, is 15,000 Deutschmarks. That's $7,500. Where some of the lawyers, in that particular case, earned fees of $10 million. And so the survivor says, wait a second, here you were, working on this case, I admit, for a year and a half, in air-conditioned offices, and I survived Auschwitz, and you get $10 million. Right? The response on the part of the lawyers is, look, you needed us.